Hello everyone, today's topic is about the State Prisoners Resolution 1880, 1818. So let's go. Preamble. Whereas reasons of the security of two Bangladesh occasionally render it necessary to place under personal restraint individuals against whom there may not be sufficient ground to institute any judicial proceedings, or when such proceeding may not be adapted to the nature of the case or may for other reasons be undesirable or improper, and where it is fit that in every case of the nature herein referred to the determination to be taken should proceed immediately from the authority of the government, and whereas the ends of justice require that when it may determine that any person shall be placed under personal restraint otherwise than in pursuance of some judicial proceeding, the grounds of such determination should from time to time come under revision, and the person affected thereby should at all times be allowed freely to bring to the notice of the government all circumstances relating either to the supposed grounds of such determination or to the manner in which it may execute it. And whereas the ends of justice also require that due attention be paid to the health of every state prisoner confined under this resolution, and that suitable provision be made for his support according to his rank in life and to his own wants and those of his family, and whereas the reasons above declared sometimes render it necessary that the estates and lands of jamindars, jamidars and talukdars others should be attached and placed under the temporary management of the revenue authorities without having resources to any judicial proceeding, and whereas it is desirable to make such legal provisions as may secure from injury the just right and interest of individuals whose estates may be so attached under the direct authority of government. It is hereby interpreted as follows. Proceedings for placing persons under restraint as state prisoners. First, when the reasons stated in the preamble of this resolution may seem to the government to require that individuals should be placed under personal restraint without any immediate view to ulterior proceedings of a judicial nature, a warrant of commitment shall be issued by the government to the officer in whose custody such persons is to be placed, provided that a person shall not be placed under personal restraint for a period longer than 2 months without the authority of a board consisting of a judge of the Supreme Court who shall be nominated by the Chief Justice of that court and another senior officer in the service of Bangladesh who shall be nominated by the President. Form of warrant. Second, the warrant of commitment shall be in that one of the forms set out in the appendix to this resolution which is appropriate to the case. Third, the warrant of commitment shall in relation to a person to be confined for reasons connected with defense, external affairs or the security of Bangladesh be sufficient authority for his detention in any fortress, jail or other places in Bangladesh, and in relation to any person to be confined for reasons connected with the maintenance of public order in Bangladesh shall be sufficient authority for his detention in any fortress, jail or other place in Bangladesh. Procedure Board, etc. 2. The provisions of subsection 2 of section 6 of the Security Pakistan Act 1952 and those of section 6A of the Act shall mutatis mutandis apply in relation to a person placed under personal restraint under this resolution as they apply in relation to a person detained under that Act. Officers having custody of state prisoners should submit periodical reports. Every officer in whose custody a state prisoner may be placed shall on the 1st of January and 1st of July of each year submit a report to the government on the conduct, that health and the comfort of such state prisoner in order that government may determine whether the orders for his detention shall continue in force or shall be modified. State prisoners in custody of Jila magistrate by whom to be visited. First, when any state prisoner is in the custody of Jila magistrate, the judges are to visit such state prisoner on the occasion of the periodical sessions, and they are to issue any orders concerning the treatment of the state prisoner which may appeal to them advisable, provided they be not inconsistent with the orders of government issued on that head. State prisoners in custody of public officer not being Jila magistrate by whom to be visited. Second, when any state prisoner is placed in the custody of any public officer not being Jila magistrate, the government will instruct either the Jila magistrate or the judge or any other public officer not being the person in whose custody the prisoner may be placed to visit such prisoner at state periods and to submit a report to the government regarding the health and treatment of such prisoner. Representation by the state prisoners to be submitted to government. The officer in whose custody any state prisoner may be placed is to forward with such observations as may appear necessary every representation which such state prisoner may from time to time be desirous of submitting to the government. Report to government regarding confinement etc. of prisoners. Every officer in whose custody any state prisoner may be placed shall as soon after taking such prisoner into his custody as may be practicable report to the government whether the degree of confinement to which he may be subjected appears liable to injure his health and whether the allowance fixed for his support be adequate to the supply of his own wants and those of his family according to their rank in life. Appropriation for allowance for support. Every officer in whose custody any state prisoner may be placed shall take care that the allowance fixed for the support of such state prisoner is duly appropriate to that object. Functions of the government. Where a person is or is to be confined in Bangladesh under this resolution for reasons connected with defense, external affairs or the security of Bangladesh, the warrant of commitment and any orders as to his release or the place of his detention shall be issued by the government and the amount of the allowance to be fixed for his support shall be fixed by the government and shall be paid by the government, and all the reports representations to be made under the foregoing provisions of this resolution shall be submitted and forwarded to the government. Subject as aforesaid, all things to be done by or the government in relation to any persons confined or to be confined under this resolution shall be done by or to the government. References in the preceding sections of this resolution to the government shall be constructed in accordance with the following provisions of this session. Attachment of status by order of government without decision of court. Whenever the government for the reasons declared in the preamble to this resolution shall judge it necessary to attach the estates or lands of any Jamidar, Jogidar, Talukdar or other person without any previous decision of court of judge or other judicial proceeding, the grounds on which the resolution of government may have been adopted and such other information connected with the case as may appear essential shall be communicated to the judge and magistrate of the district in which the lands or estates may be situated and to the Sodor Devani Adalat and Nizamot Adalat. Management of attached estates. First, the lands or estates which may be so temporarily attached shall be held under the management of the officers of government in the revenue department and the collections shall be made and adjusted on the same principle as those of other estates held under caste management. Management of attached estates. First, the attached lands not liable to sale in execution. Second, such lands or estates shall not be liable to be sold in execution of decrees of the civil courts or for the realization of fines or otherwise during the period in which they may be so held under attachment. Government to arrange for a satisfaction of decrees. Third, in the case mentioned in the preceding clause, the government will make such arrangement as may be fair and equitable for the satisfaction of the decrees of the civil courts. Rule as to cases where government orders release the estate from attachment. Whenever the shall be of the opinion that circumstances which render the attachment of such estate necessary have ceased to offer and that the management of the estate can be committed to the hands of proprietor without public hazard or inconvenience, the revenue authorities will be directed to release the estate from attachment to adjust the accounts of the collections during the period in which they may have been superintended by the officers of the government and pay to over the proprietor the profits from the estate which may have accumulated during the attachment. Extent. This resolution so far as it relates to the confinement of persons for reasons connected with defense, external affairs or the security of Bangladesh extends to the whole of all the governor's provinces and so far as relates to other matters extends to Bangladesh except Slint. Governor's province. In this resolution, reference to a governor's provinces mean East Pakistan and those areas in West Pakistan which immediately before the 14th of October 1955 were comprised in the Punjab, the Northwest Frontier Province, Sindh, Baluchistan, including leased areas in the Baluchistan States Union of the states of Bhavalpur and the state of Khairpur and those areas which immediately before the first day of July 1961 were comprised in the Federal Territory of Karachi. Thanks for watching the video.